Hi, my name is Matthew Eason. I'm one of the attorneys in the Sacramento Workers Compensation Law Group. And in this video, I want to talk to you about some issues in the workers' compensation world as it relates to car accidents. I've been practicing law here in Sacramento for over 25 years. My firm has handled thousands of cases involving car accidents, slip and falls, trip and falls related to workers' compensation and otherwise. And in this video, I want to explain to you some of the issues that we deal with so you can understand what you might face in your case. One of the most contentious areas of workers' compensation as to whether or not an injury arises out of employment has to do with driving. If you're driving for the benefit of your employer, workers' compensation applies. If you're not, workers' compensation does not apply. Sounds simple, but not always the same way. For example, generally speaking, if you are commuting to and from work, that is not for the benefit of the employer, that's your own personal benefit to get to your job. However, the law provides that if part of that commute you are carrying tools for the benefit of your employer or equipment for the benefit of your employer, then workers' compensation does apply because you are now helping your employer out during those commute hours. Likewise, the law has been expanded to say that if the employer has provided you a vehicle, then workers' compensation applies. There are several other ways that it might apply to, and in particular it has to do with special circumstances or special errands. If you are on the way to work and your employer says, will you stop at the hardware store and pick up something for me? Well, now that commute has turned into a special errand for the benefit of your employer, and workers' compensation would apply. Another example of a special circumstance in which driving to and from work would be compensable has to do with special circumstances going to work after hours. For example, if you normally work a 9 to 5 shift, and now your employer is asked you to come in the middle of the night to cover for somebody else or to handle any emergency, that after hours coming into work is not a normal commute, and thus some of the law provides that that would be considered workers' compensation. Likewise, if your employer has asked you to attend a conference out of town or go to a client's building or client's office for a meeting, that is for the benefit of your employer, and thus commuting or driving to those premises would be considered workers' compensation. At first blush, it seems very simple whether or not an injury arises out of and in the course of employment. If you're hurt on the job, it's workers' compensation. However, as you can see from this video, there are various situations in which the lines get blurred, and that's when a competent workers' compensation attorney can help you determine is that workers' compensation, and also help you determine whether or not you want it to be workers' compensation. If you've been injured and you're concerned about whether or not it's considered workers' compensation or not, I encourage you to contact myself or one of the attorneys here at the Sacramento Workers Compensation Attorneys Law Group. Our address is 1234 H Street, Suite 100, Sacramento, California, 95814. Our phone number is 916-288-9193, or you can find us on the web at sacramentoworkerscompensationattorney.com. Thanks for watching.